Hey, what is up, everyone? We are back here with Law, Liberty, Logic. We got another great stream for you talking about some Florida legal issues. If you have not seen this channel before, you're fresh to it, do make sure to subscribe to the channel today. Make sure you click that notification bell as well, so that way you can get all of our latest videos and topics. We've been doing a lot of good stuff lately ever since I started doing these streams. So it means a lot to me when I see people come on by and subscribe and a comment. So that encourages me, and then it makes you want to keep doing more of these overview videos. And today we have a really interesting topic. We're going to be talking about Florida's justified use of defensive force statute. And that is quite the testy subject, because lots of people have different ideas about what it is that you should or shouldn't use defensive force over. But fortunately, Florida has very strong protections for justified use of defensive force. And that means that, in a lot of situations, the law is typically going to be more on your side if you need to use defensive force. So we're going to go over that statute. It won't be over every single possible situation, but it will be over the core aspects of it and some key things to think about. And just remember, as always, this is just for educational purposes only. If you have a specific situation for yourself, definitely go and seek an attorney in your area, so that way you can get help for your legal issue. All right. So the Florida Justifiable Use of Force and Stand Your Ground is developed in a statute. So let me just pull back here. This statute is 776.012. So basically, the Florida legislature has made it so that this information, this legal parameter, has very specific articulation. It's not just simply case law here, but it's actually written down in the statutes. And again, just one more reminder. Again, this is just for informational purposes only, educational purposes. It's not intended as legal advice. All right, let's dive into it. So Florida statute 776.0121, non-deadly force. So it's important to realize that there are differences between when you are able to use certain levels of force, right? You can't exactly just be like, oh, this person accidentally dropped a pencil on me and then they moved and I had to shoot them, right? There's definitely levels of what's considered reasonable versus, for non-deadly force versus deadly force. So Florida explicitly protects use or threatened use of non-deadly force in self-defense in specific situations. So again, very narrowly focused. This is about non-deadly force, right? So there are certain situations where this is explicitly protected. And that's not just the actual use of it, but threatened, right? Someone who's making a threat toward that end, of course, you don't have to wait to be harmed, before using defense in certain contexts. So 776.012 says use or threatened use of force in defense of person. A person is justified in using or threatening to use force. So again, in defensive context, you can use the force or you can threaten to use the force, except deadly force. So again, just reminding ourselves here, this is non-deadly force against another when and to the extent that the person reasonably believes that such conduct is necessary to defend himself or herself or another. So another key part, you can also be defending another person against the other's imminent use of unlawful force. So imminent is another key word. We'll come back to that. A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force. Very important to take note of this. Florida is not a duty to retreat state, fortunately. And it's very important, because I personally think that a duty to retreat is absolutely insane. It's like saying, oh, hey, if you're getting attacked by somebody, you have to be on the run now. That's crazy to me, that, you should be able to defend yourself against some robber, some mugger, some murderer, some rapist. You shouldn't have to go and flee. You should be able to stop them and save yourself. So I'm very glad that they have that here. So let's break down just those elements in specificity. So again, this is just homing in on what it is that you have to have, right? So repeating the statute here, the person reasonably believes, right? So it's a reasonable person standard, and that such conduct is necessary to defend himself or herself or another, right? So you're defending yourself or another person against the other's imminent use. So key word, it has to be imminent. It can't just be some theoretical future thing. It has to be someone about to do this thing. Not like, oh, hey, I'm going to get back at you, in 2026 or something, right? It's has to be something that is presently happening, about to happen, of unlawful force, right? So you can't hurt somebody for using lawful force against you, right? So you can't use non-deadly force. For example, if you're being kicked out of a bar and you're fighting them, and the bar bouncer's like, hey, you got to get out of here, right? If you're not supposed to be there, you're causing disruption, and all of a sudden you're fighting them back. Well, you're going to be the one who gets in trouble, because the bar and the bartender and the bar bouncer is going to have the right to remove you if you don't, leave. So they're able to say, hey, you need to get out of here. So remember that you must meet each element to satisfy this criteria, right? And we won't get deeply into all the possibilities of reasonably believes. It certainly is a standard that is something that's held by the court, where they kind of create this somewhat amorphous reasonable person standard, but it's often kind of fact specific. It depends on the jury, but let's just say that it's going to require, some material element of suggesting that a person would see, oh, someone's attacking them, right? It's not going to be like, oh, I saw this magical fairy unicorn that, is some schizophrenic delusion kind of thing. It has to be something that is material the jury is going to see and be like, oh, okay, yeah, it's reasonable to see someone swinging their fist at you kind of thing, that kind of situation. So just remember that all these things must be satisfied for non-deadly force. So reasonable standard, we're going to develop that just a little bit more. It says here, there's the case here, 3D1 Southern 3D for Pace v. State from 2024. So whether a defendant was justified in using a particular level of force against another must be evaluated in accordance with the objective reasonable person standard. It is citing a bunch of other courts. Under that standard, the legal question is to be resolved in all SYG, which stands for stand your ground cases, is whether a reasonable and prudent person in the same position as a defendant would believe that the level of authorized force used was necessary to prevent the harm or offense for which such force is statutorily permitted. So again, while there is some elaboration here saying, okay, here's our standard, reasonable, prudent person in the same position would believe that the force was necessary to prevent the harm or offense, it still is technically going to be a bit subjective, right? There's no absolute definition that is going to impute the truth for all cases. So this is where it gets to be, you have a charge to the jury, and the jury is going to sit there and weigh whether they think that it's reasonable that someone would, believe that this defensive force is necessary. Usually, most juries are at least, typically reasonable about upholding this. It's especially in Florida. Fortunately, no one's usually too crazy, and it's stopping someone from trying to actually defend themselves. But it's just a part of that calculation. At the end of the day, yes, there is a statute that says reasonable person. There is case law that talks about that standard of reasonable person. But at the end of the day, it's still going to be up to a jury to kind of wade through and whether they agree with you that it was reasonable, based on them essentially putting themselves in their shoes based on this case law and interpretation. So in addition to this statute, there is, of course, more. There is not just non-deadly force, there's also deadly force, right? So it's important to note here that, there's that very fine line, and that each one's going to have its own special set of circumstances, right? Can't just use deadly force right away just because someone, touches your shoulder like with a finger and taps it, right? That's a great escalation. So you got to be careful. However, the good news is that the deadly force otherwise is relatively strong. So Florida explicitly protects use or threatened use of deadly force. So again, just like before, use or the threat of that deadly force. I'm gonna have a quick water here. In self-defense in specific situations. So a person here with section 2, a person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony. So very interesting here. We have multiple elements of consideration. It can be imminent death. It could be great bodily harm. It could be a forcible felony. Okay, that's getting interesting. More opportunities for this to come into play. A person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in a criminal activity and is in a place where he or she has a right to be. So there is a lot to digest here in terms of all these elements. There's a lot of conditions. So let's walk through those conditions carefully and think through what each of them means. So using or threatening deadly force elements, right? This is what is going to be required. If he or she reasonably believes, so we have that reasonable person standard, that using or threatening to use such force is necessary, right? So this force is necessary, not that it's not necessary, but is necessary to prevent imminent death. So option one, you're stopping death, or great bodily harm to himself or herself or another. So great bodily harm, is usually going to be something where it's like you're worried about, your arm getting cut off or you're getting stabbed or something serious, not like, oh, I got a paper cut, but, someone's going to cause you great injury, going to injure your organs, going to possibly hit you in a way that you might bleed out to death, or might cause, brain injury, that kind of thing. All considered great bodily harm potentials, felony level actions potentially. Or to prevent the imminent commission of a forcible felony. So forcible felony, it's like, okay, so, felony is a higher degree of legal sanction and harm. Obviously it's going to take you past a year potential in jail and put you into prison if you have a felony. So you might be wondering, well, what will that involve? Well, we'll go over that and we'll talk specifically about what it is because they do cover what that is. So forcible felony, right? 776.08, forcible felony. Forcible felony means treason, murder, manslaughter, sexual battery, carjacking, home invasion, robbery, burglary, arson, kidnapping, aggravated assault, aggravated battery, aggravated stalking, aircraft piracy, unlawful throwing, placing or discharging of a destructive device or bomb, and any other felony which involves the use or threat of physical force or violence against any individual. So, they do have specifics. They lay out, hey, here's clearly, these forcible felonies, but they do also make a catch-all, which is probably the thing to take away the most, is that if it's a felony and you're using or threatening physical force or violence against any individual, that's a forcible felony. So that's where it comes in, especially for defensive force, where you can use or threaten to use deadly force if someone is threatening against you something that is felonious, that is a threat of physical violence, or physical force. So someone is coming at you and they're looking to stab you with a knife. They're pointing a gun at you. They're using obviously a bomb here. They're maybe trying to set your house on fire. They're committing a robbery, which means they're pulling something off you. They're using force to steal something off your body, carjacking, those kinds of things. Most certainly, defensive force that is deadly is going to be considered acceptable there in most all cases. And you can threaten it, or you can even use it. In other words, not just, make the threat, but follow through on the threat and shoot back, or use high levels of physical force to fight back with someone, smack them with a bat, stab back, whatever it is. It's a pretty wide net there when someone is using that level of threatened violence against you. And again, it's very important to make sure that you're following along with those criteria of conditions. Just going back here. So that imminent element, right? There's an imminent part. Again, just focusing on that for a moment. Remember, imminence means that it's just about to happen, right? Imminent means that, oh, this is about to happen in the next moment. It doesn't mean someone's making a threat about a theoretical future or 10 years from now, or, oh, someone said something mean online, and they're 3,000 miles away across the United States, right? So if you're using this defensive force, you can't be like, I'm going to go pack up my car and go fight this person, across 2 states, right? It has to be something where the person is relatively in your physical proximity, and this is something that's about to happen. Otherwise, you're going to probably be in some trouble, right? So keep in mind that, these defensive conditions for the non-deadly and the deadly require that you satisfy these different elements. And if you don't, then you could be the one who's catching a charge. So you got to be extra careful about that. This the statute here where we're just talking about where we're dealing with deadly force, forceful felony, that's often encapsulated as the stand your ground law. So a person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in a criminal activity and is in a place where he or she has a right to be. So stand your ground is, again, itself two-pronged, right? You can't be yourself engaged in a criminal activity. If you're engaged in a criminal activity, well, you might be out of luck on that potentially. And then you're in a place where he or she has a right to be, right? So is the other part to this. You can't be going and doing something where you're not supposed to be. If you're going and trespassing somewhere else, on someone else's property, well, then you didn't have a right to be there. If you've been kicked out of a place, right? Maybe you were a patron at some restaurant or something like that, but the owner says, hey, you're being belligerent. You got to get out of here. You're trespassed. You're done, right? Well, then you might no longer have a right to be somewhere because you've been booted. So, those are some of the edge issues, but generally speaking, you have a right to be at your home. You have a right to be in public. Generally, you have a right to be, until you're trespassed otherwise in a, private business, that kind of thing. So using your self-defense in any of these situations, typically you're going to be fine, meeting the other criteria, as long as, you had the right and ability to be there. It's just, of course, if you're a criminal and all of a sudden you're getting in trouble while also being a criminal, you might be in a testy situation. Or if you're trespassing, you're going to be in a testy situation. So it's really, something that you just have to be aware of whenever you're deciding to think or do about these things. Of course, in some cases, there's going to be people who, for whatever reason, even if they're not in the place they're supposed to be, they use the defensive force because they just don't want to die. And that there are weird situations like that. Like, for example, a pettier criminal meeting a worse criminal situation. You think like some, horror movie documentary thing, right? Someone just like trying to steal a candy bar and then they run into Jeffrey Dahmer kind of situation, right? You might get those situations in the rarest of senses that you have a less worse bad guy and then a really bad guy facing off, right? Then they'll have their own little legal issues that they'll have to meter out at that point. But generally speaking, for most people, you're just going to be dealing with being able to use your defensive force if you're otherwise not engaged in doing something criminal yourself. So just got to make sure that, you follow all those things. And, and good to see you here, Rob. Thanks for coming on by. Yeah, there's 5,000 ways to be charged with a felony. Yes, there's a lot of ways that you can be charged with a felony for sure. But of course, the key here is just to, basically make sure that it's pretty clear you're not engaged in a felony. Of course, there's many ways to be caught up in the legal system these days. It's so easy to commit, a crime. Technically, that there's, the many different, I think, ways you can commit a crime in that book. 3 Felonies a Day. I think that's a popular book talking about that specific situation, how technically people unwittingly create federal felonies all the time. But in the state of Florida, you're probably, are not going to be doing something like that. Most likely in that situation, you're probably not going to be like, oh, wow, you sent an email without a certain thing, or you had a fish you weren't supposed to have, that kind of thing, while defending yourself against a killer. But hey, you never know. That's what makes for these crazy stories and these crazy legal issues, come to a head is those weird situations. But hopefully for those watching this, you never have to face someone actually attacking you in that way. And hopefully if you do, you just know that generally speaking in Florida, if you're in a place where you're supposed to be, you have an imminent threat against your body, great harm. Someone's coming to attack you, possibly breaking your home, that kind of thing. You don't have to retreat. You can defend yourself. And the legal, structure in Florida is going to generally defend people who are earnestly defending themselves against genuine bad guys, especially in the context of being your home and being places where you have a legal right to be, such as, being in public, that kind of thing. So, all right. So there is this interesting case here. I did want to just note in this wrapping up of these, basic concepts with non-deadly and deadly defensive force. And that's at the Florida Supreme Court in 2018 in State v. Peraza. they affirmed the stand your ground law's applicability as to any person, including applying it to police officers. So that's kind of interesting because, you might wonder, well, who does this apply to, right? Who can use this defensive force? Who's going to be protected? And so in this situation, there's a police officer who wanted to rely on stand your ground because they were being attacked and they wanted to use defensive force to protect their life. So there is qualified immunity, which is its own separate huge topic that, I could do a video on as well. I'd love to. But this is something that transcends that. In other words, a police officer could rely on stand your ground instead of qualified immunity, which, my opinion would be a lot better than qualified immunity, which is just, to me, crazy. It's overbroad and covers so many things. Whereas this is much more narrow, right? Stand your ground here. It's like, oh, okay, you're actually having your life threatened by someone. They're imminently about to stab you to death or kill you or do something, that's extremely violent, like an armed robbery situation. Okay, yes, you have something material to defend your life over, and that protection should apply to anybody. It should apply to any person. They should be able to defend themselves and their life from a genuine bad guy who is looking to take your life, or steal from you and then, leave you for dead, basically. So in this case, they say, although neither of the two statutes defines the word person, it must be given its plain and ordinary meaning. This is from Green v. State. They were just saying, a plain meaning rule and common understanding. Person refers to a human being. And they're citing Webster's Third New International Dictionary, 1993 edition. So human being, which is not occupation specific and plainly includes human beings serving as law enforcement officers. So essentially, the Supreme Court of Florida said, hey, this stand your ground, you're in Florida, applies to any person, right? So you're a human being, okay, stand your ground. So this should protect anyone regardless of occupation at a bare minimum. It could apply to anyone, else otherwise, right? Who is otherwise not, committing a crime technically on the books. So you'd expect someone who maybe is a non-citizen, but they're here, work visa or something like that. They should be able to use stand your ground because they're not technically doing anything illegal. Obviously, if, we're going to the broader sense of, this is about fundamental rights and they should apply to all people. It transcends the Constitution. Well, that's its own separate topic. But as far as the actual statutes in Florida, they say person. Okay, well, any person who's a human being in Florida who's not otherwise, engaged in criminal activity, breaking the law, they can use this against, anybody else, as long as they have the rightful ability to be where they are, for at least for the deadly force portion. And of course, non-deadly force, generally speaking, you can push someone off you, that kind of situation. Just noting here, backing in toward the beginning, where they say non-deadly force, they don't mention there the rightful place to be aspect, right? They just say a person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force, right? So the difference there, of course, is that nuance we were talking about before, which is that when you're using deadly force, they go that extra mile of saying, well, you better do it in a place you have the ability to be. But if you don't have the ability to be, like, again, that criminal, less worse criminal versus, worse criminal, well, maybe you're just going to use non-deadly force to shove the Jeffrey Dahmer off you and flee if you were already breaking in somewhere and then he caught you, right? Otherwise it could get legally dicey. So just important to know those differences and to just, be careful about what it is that you're doing in defense, but just being able to rest on the fact that generally speaking, you're able to take out bad guys who are trying to do great bodily harm, trying to kill you, try to commit a forcible felony against you. You can use or threaten to use a deadly force against those persons where you have a rightful place to be. You're not committing a crime otherwise. And of course, the wider net of non-deadly force, of course, you can stop an imminent use of that as well. So I hope that you have enjoyed this presentation and have found it informative and enlightening. Obviously, I did not go into every single nuance of every single situation possible. I mean, that's fun to talk about. Maybe throw down a comment if you have some fun concepts or maybe something you've seen in the news. Definitely love taking a look at news stories, and maybe I'll do some of that next. Maybe I'll do some breakdowns of different situations, the police body cam footage kind of thing. I've done that before, and I've thought about doing some more videos talking about these situations, especially in a Florida context. So make sure to go ahead, and if you haven't already, subscribe, to this channel, get the notification icon clicked, and I'll deliver more of these educational videos for you, and we'll have some more fun discussing Florida legal issues. Thanks so much, everybody. Talk to you soon.